I'm Drew Stevenson, and this is a lecture for my professional responsibility class about ABA Model Rule 4.1, Truthfulness in Statements to Others. Please keep in mind that some of the model rules are what we might call truth rules or required disclosure, like the candor to the tribunal and so forth. And then we have other rules that are confidentiality rules, primarily 1.6. And sometimes these rules are in tension. And on the MPRE, you could be asked a very difficult hypothetical where it asks you to pick which one wins. So let's take a look at our rules. There's an A and B section and then a few comments that are worth talking about. Here's our rule. 4.1, in the course of representing a client, a lawyer shall not knowingly, A, make a false statement of material fact or law to a third person, or B, fail to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, unless disclosure is prohibited by 1.6. So that's our A and B section. Just to unpack it for a moment, the first is false statements of material fact or law, and that's basically anyone. Although when it says third person, we're usually not focused on your relationship with your client right now, but it could be the other party. This could be jurors, this could be witnesses, and so forth. And a material fact would be something that matters, right? Not just you look good today or I like your haircut, but something that relates to the representation where you're genuinely misleading or deceiving someone. And the same with a fact of law, telling someone that's a felony in this state when you know it's not, or telling someone that something is perfectly legal when you know it's not. And the same is true for failing to disclose something, being selective in your truth telling as a way to deceive and mislead other people. And notice that it says, unless disclosure is prohibited by 1.6, that's our duty of confidentiality. Please keep in mind that the way this is phrased, it means if you have to pick between which of these two rules applies to a situation, this rule or 1.6, it's basically saying 1.6 wins most of the time. But also keep in mind, we've already studied 1.6 at this point in my course, that 1.6 has a number of exceptions that may apply, some of which are similar to this rule. So let's continue. Again, this is our rule. You shall not knowingly make a false statement of material fact or law to a third person, or fail to disclose a material fact to a third person when it's necessary to avoid assisting in crime or fraud. Now, also notice that it's not just you have to say something to make sure the other person doesn't misunderstand the situation. We do have that type of affirmative duty to clear up misunderstandings with some of our other rules, like a person thinking that you are representing them when you're not. Or again, candor to the tribunal. If a judge has asked you a question or your client has lied to a judge, you may have an affirmative duty to volunteer information. But otherwise, the duty to volunteer information is to avoid crime and fraud. Let's move on. Comment 1, I'm just going to hit a few of the highlights from the comments that I think are useful for the MPRE. A lawyer is required to be truthful when dealing with others on a client's behalf, but generally has no affirmative duty to inform an opposing party of relevant facts. A misrepresentation can occur if the lawyer incorporates or affirms a statement of another person that the lawyer knows is false. And so notice the distinction here, and the comments really backpedal from the thrust of the rule if you were taking it very literally. So here it's saying that you don't really have to tell the opposing party about things that you know about that they maybe have misunderstood. You can't lie to them. You can't tell them falsehoods. But if they're under the impression, for example, that your client doesn't have a criminal record and they haven't asked you, then you can leave them in their ignorance. In other words, you don't always have to do the other side's job for them. Now, balance this with the fact that in litigation, we have really extensive discovery rules, and so you're probably going to have to disclose a lot of information that is uncomfortable or unfavorable information in discovery anyways. But you don't have to set the other side straight under this rule if they are simply wrong about things. Okay, comment 2. This rule refers to statements of fact. Whether a particular statement should be regarded as one of fact can depend on the circumstances. Under generally accepted conventions in negotiation, certain types of statements ordinarily are not taken as statements of fact. And what are we talking about here? Well, here in the comments, there was a big debate at the ABA about adopting this rule, and the compromise really gets embodied in or codified in comment 2. With the people who were concerned that the rule was forcing too much disclosure from lawyers. Estimates of price or value placed on the subject of a transaction and a party's intentions as to an acceptable settlement of a claim are ordinarily in this category. What category? The category that is not considered a statement of fact. So is the existence of an undisclosed principal, except where non-disclosure of the principal would constitute fraud. And so this basic compromise is saying that the rule of truthfulness doesn't mean that you have to you can't bluff a little bit in negotiations about asking for a higher amount. A lot of people approach negotiation asking for high or low, expecting that at some point they'll meet somewhere in the middle. So because they want some room to negotiate, they either overstate or understate their position at the beginning. And that is permissible under the rule because it's assumed that your initial settlement demand or offer might not be an actual statement of fact about your willingness to settle. Or saying something like, we're not really interested in talking about settlement, we just want to go to trial, when the fact is that you think you might entertain a settlement offer and you're playing hard to get or a little bit, that is also permitted and not considered a statement of fact. Conversely, for example, if you, let me give an example from transactional settings. Let's say that your client owns a piece of real estate that they're interested in selling. And you find a prospective buyer, and the prospective buyer says, how much would you sell this for? And your client decides to play hardball and wants you to say, we want some astronomical amount, something that you know the property, that's a lot more than the property is actually worth. You can go ahead and say, we think it's really worth a lot. We think it's worth millions and millions of dollars. And that's just a negotiation strategy of bluffing according to comment 2. On the other hand, if you say we had the property appraised and it was appraised at $2 million and you're just making it up, that is a misrepresentation of a material fact because you're claiming that there was an actual appraisal and you're lying about what the appraisal value was. So that would be a misrepresentation. If you are merely expressing an opinion, we think the property is worth a lot more than that, you're allowed to do that. Okay, let's move on. Comment 3. Paragraph B overlaps somewhat with Rule 1.2d. You may remember that, which also forbid helping a client commit a crime or fraud. 1.2 is the rule about allocating decision-making between the lawyer and the client. And you may, just not to go too far afield, you may remember that the rule said, in the end, you're supposed to do what the client wants, but not if the client is asking you to commit a crime or help the client commit a crime or fraud. Here, this is saying essentially the same thing, except it's especially specifically focused on situations where the client's crime or fraud takes the form of a lie or misrepresentation. And then we have this concept of noisy withdrawal. Ordinarily, you can avoid assisting in a crime or fraud by withdrawing from the representation. Sometimes the lawyer may need to give notice of the fact of withdrawal and disaffirm any prior opinion, document, or affirmation. What are we talking about here? Sometimes if the client wants you to commit a crime, you can just say, you know what, I'm not going to help you with that. I'm withdrawing from the representation. Remember that sometimes all you have to do is tell the client, that's a crime, we're not going to do that. And if the client says, oh, sorry for suggesting it, you can continue with the representation. But if the client is insisting that you assist them with a a crime or fraud, then you have to withdraw. Sometimes withdrawal is not enough because you realize that even the work you've done up to that point is helping the client, part of the way to committing the crime or fraud, and so you may have to notify another party, let's say, by the way, I am withdrawing and I hereby disaffirm or disavow the prior documents that I signed off on or submitted. You don't have to tell them why, but if they're a lawyer, they know what that means. In extreme cases, other statutes may require lawyers to disclose information to avoid being deemed an accessory to a crime. This is still comment 3. If that is the only way to avoid assisting a crime or fraud, Rule 4.1b requires the lawyer to disclose the information unless it says prohibited by Rule 1.6, but remember that 1.6 has a very similar exception that you are allowed to make disclosures to avoid sharing in a client's liability or to defend yourself and so forth. So if you are in this situation, 1.6 will then govern, but you may have situations where you have to avoid being an accessory to a crime or fraud. Here's a review question to see if you've been paying attention. An attorney needs to obtain a document for a client that is on file at City Hall in the records office. Is it permissible for the attorney to lie to the staff and claim to be a lawyer from the governor's office in order to gain access to restricted records? A, yes, or B, no. Now, that's supposed to be an easy question. Hopefully you are paying attention. If you're a little stumped by this, maybe you should rewatch the video. And that concludes our video about ABA Model Rule 4.1.